In this video, I'll introduce the fifth principle of IDEA, related services and supplemental aids. You can find the videos on the first four principles of IDEA in the description section below. Once related services and supplemental aids are considered essential in a FAPE, they must be provided regardless of cost. But courts have differentiated between medical services and health services. Under IDEA, school districts are not required to provide medical services, which are provided by a licensed physician, except for diagnostic and evaluative purposes. But the district must provide health services, which are provided by a nurse or other qualified persons, if those services enable the student to attend school and benefit from instruction. The difficult part here is to determine whether a service, medical versus educational, necessary. Some courts have considered that medically necessary services may be necessary for students to benefit from special education. In the case Cedar Rapids Community School District v. Garret F. 1999, a student required a wheelchair and was dependent upon a ventilator. He required assistance in attending to his physical needs during the school day. The school district declined to accept financial responsibility for the student's services in order for him to be able to attend school. The school district believed it was not legally obligated to provide one-on-one care. An administrative law judge concluded that the IDEA required the school district to provide school health services, which are provided by a qualified school nurse or other qualified person, but not medical services, which are limited to services provided by a physician. The distinction between health services and medical services does not just depend on the title of the person providing the service. Instead, the medical services exclusion is limited to services that are in the special training, knowledge, and judgment of a physician to carry out. The administrative law judge therefore concluded that the IDEA required the school district to bear financial responsibility for all of the services in dispute, including continuous nursing services. The school district appealed. The district court and the Eighth Circuit affirmed, despite arguments from the school district that such one-on-one care is too costly and too involved to be considered anything but medical in nature. This case then went to the U.S. Supreme Court. The question here is, do schools that receive federal funding under the IDEA have to pay for one-on-one nursing assistance for certain students with disabilities? In the 7-2 decision, the Supreme Court held that IDEA-funded school districts must provide the services that are related to keeping the child with disabilities in schools and able to access educational opportunities available to others. Justice John Paul Stevens delivered the opinion of the court. He wrote, "The district may have legitimate financial concerns, but our role in this dispute is to interpret existing law, defining related services in a manner that accommodates the cost concerns Congress may have had. It's altogether different from using cost itself as the definition. Given that Code of Federal Regulation does not employ cost in its definition of related services or excluded medical services, accepting the district's cost-based standard as the sole test for determining the scope of the provision would require us to engage in judicial lawmaking without any guidance from Congress. It would also create some tension with the purposes of the IDEA. It is undisputed that the services at issue must be provided if Garret is to remain in school. Under the statute, our precedent, and the purpose of the IDEA, the district must fund such related services in order to help guarantee that students like Garret are integrated into public schools. Justice Clarence Thomas and Anthony Kennedy dissented. Justice Thomas wrote, "The majority's extension of Irving Independent School District v. Tetral, 1984, which was a case about the definition of related services and medical services, is unwarranted and ignores the constitutional mandated rules of construction applicable to legislation enacted pursuant to Congress' spending power. The majority does not explain, however, why services that are medical in nature are not medical services. Not only is the definition that the majority rejects consistent with other uses of the term in federal law, it also avoids the anomalous result of holding that the services at issue in Tetral, as well as in this case, while not medical services, would nonetheless qualify as medical care for federal income tax purposes." Justice Anthony Kennedy wrote, "Congress enacted IDEA to increase the educational opportunities available to disabled children, not to provide medical care for them. The IDEA represents an ambitious medical effort to promote the education of handicapped children. As such, where Congress decided to require a supportive service, including speech pathology, occupational therapy, and audiology that appears medical in nature, it took care to do so explicitly. Congress specified these services precisely because it recognized that they would otherwise fall under the broad medical services exclusion. Indeed, when it crafted the definition of related services, Congress would have, but it chose not to, include nursing services in this list. Because IDEA was enacted pursuant to Congress' spending power, our analysis of the statute in this case is governed by special rules of construction. We have repeatedly emphasized that when Congress places conditions on the receipt of federal funds, it must do so unambiguously. This is because a law that conditions an offer of federal funding on a promise by the recipient amounts essentially to a contract between the government and the recipient of funds. As such, the legitimacy of Congress' power to legislate under the spending power rests on whether the state voluntarily and knowingly accepts the terms of the contract. There can, of course, be no knowing acceptance if a state is unaware of the conditions or is unable to ascertain what is expected of it. It follows that we must interpret spending clause legislation narrowly in order to avoid saddling the states with obligations that they did not anticipate. The majority's approach in this case turns this spending clause presumption on its head. We have held that in enacting IDEA, Congress wished to require states to educate handicapped children with non-handicapped children whenever possible. Congress, however, also took steps to limit the fiscal burdens that the states must bear in attempt to achieve this laudable goal. These steps include requiring states to provide an education that is only appropriate rather than requiring them to maximize the potential of disabled students, recognizing that integration into the public school environment is not always possible. and clarifying that, with a few exceptions, public schools need not provide medical services for disabled students. A school nurse cannot provide the services that the student requires and continue to perform her normal duties. To the contrary, because the student requires continuous one-on-one care throughout the entire school day, all agree that the district must hire an additional employee to attend solely to the student. This will cost a minimum of $18,000 a year. Although the majority recognizes this fact, it nonetheless concludes that the more extensive nature of the services that the student needs is irrelevant to the question whether those services fall under the medical services exclusion. This approach disregards the constitutionally mandated principle of construction applicable to spending clause legislation and blindsides unwary states with fiscal obligations that they could not have anticipated. When parents enroll children at private schools without seeking tuition reimbursement from the public school district, the district must provide equitable services to all eligible students with disabilities attending private schools located within the boundaries. What do equitable services mean here? Equitable services are not the same as the services students would receive if they attend public schools. Students enrolled in private schools by their parents have no individual right to receive special education and related services that are equal to what the public school would provide. Under these circumstances, parents and students do not have right under IDEA as procedural safeguards and an entitlement to FAPE. In this case, school districts must first initiate and conduct meetings to develop, review, and revise a services plan for the child. And second, ensure that a representative of the religious or other private school attends each meeting. If the representative cannot attend, the school district shall use other methods to ensure participation by the religious and other private school, including individual or conference telephone calls.